But now we are going to turn our attention to one of the hardest nuts that the EU has to crack when it comes to talking about migration and asylum policy, one of the most difficult issues that faces European leaders. Delighted to hand over to Marie de Sommer, Senior Policy Analyst and Head of the European Migration and Diversity Programme at EPC, to talk with her guests about the EU's reckoning with borders. Marie, over to you.
Thank you very much, Jackie. And please, Tineke, do join me. Good morning, everyone, and a very warm welcome to this session on the EU's reckoning with borders, indeed. I am very pleased to be able to chair this conversation with, on the one hand, Tineke Strik, Member of the Parliament for the Greens, also professor at the Radboud University of Nijmegen. We're also joined on the screen by Vladimír Šimoňák. Vladimír is the Director of the Center for Crisis Management at the Slovak Ministry for Foreign Affairs. A very warm welcome to you as well, Vladimír. I'll dive straight in, and I'll start by stating that in line with the general conceptualization, of course, of this Jubilee conference, we will not only look at the present-day challenges, but we'll also seek to frame these challenges within their past developments. And on that note, I would like to start by taking my panelists back to the year 1985. 1985 is the year that the Schengen Agreement was signed, a reckoning with the EU's internal borders, an agreement to abolish these internal borders. That reckoning with internal borders also immediately led to a reckoning with external borders, because the external borders were, of course, to become joint borders in that new free movement space. Agreements were quickly made after Schengen to strengthen the control over those external borders and also to organize the responsibility over asylum seekers in that border-free zone. I am, of course, as my panelists will be aware, referring to the Dublin Convention, currently the Dublin Regulation, signed in 1999 as a flanking measure to Schengen. In spite of these early and very clear policy interconnections between the two systems, in fact, in the design of their legal framework itself, no further formal links were made, at least not links of consequences. So, and more specifically, a failure to abide by the rules in one system, for instance, in Dublin, wouldn't necessarily have consequences for access to the other system, Schengen in casu. And the absence of these formal legal links, in spite of the policy connections that are clearly there, is increasingly under pressure, particularly in the last years. There are many examples of how that pressure has manifested itself, but the most obvious one, and the one that is also most covered, is the fact that the Schengen free movement zone hasn't been border-free since 2015. Since 2015, several member states, particularly in Northern Western Europe, have reintroduced internal borders, and they've justified these reintroductions by pointing to secondary movements, onward movements of asylum seekers from their countries of first arrival to other, typically Northern Western states, in breach of the Dublin rules. Against this background, I want to hear from my panelists how they view this situation. Is it justifiable? Is it also realistic to make the functioning of Schengen dependent on the good functioning of Dublin, also bearing in mind the big problems we have with the Dublin situation? Would this be a catching up with historical realities? And therefore justified, or is there a danger in it as well? Does it risk undermining Schengen? Schengen also being the most prized EU achievement according to several public opinion polls. I'll start with Tineke and I'll then move to Vladimír.
Thank you very much, and I like that straight going to the core of the problems. Thanks first of all for inviting me, and congratulations, of course, with this jubilee. Yes, it's a very essential question. How does Schengen link to the Dublin and the whole common European asylum system? It's true that with the Schengen agreement, there was immediately already a provision on the allocation of responsibility for asylum seekers. The idea was, and by that time we had only 5 states, the Benelux, Germany and France, that said, okay, we all have our external borders of Schengen, and let's make sure that there's only one member state responsible for dealing and examining the asylum claim and for granting protection if necessary, in order to avoid or prevent asylum shopping, as the way it was called, like that, so that there's no use for people moving further onward to another country. So, of course, in that sense, there is a certain is an important link towards abolishing internal border control and the way that we allocate or distribute responsibility for asylum seekers. But after that, actually, you saw this separation, because now Dublin is part of the whole common European asylum system, based on the principle that it should not matter for an asylum seeker where he submits his application, because in all countries you have the same standards on reception, on procedures, on qualification of the status, of determining the status. So that's a theory, actually. It doesn't matter. So therefore, you can have only one chance for an asylum seeker to ask for asylum. But the practice is completely different, of course. These standards are on paper guaranteed, but they are not there in practice. And that means, of course, there is a lot of reasons for an asylum seeker to travel onward and try to have a chance in another member state. And I think this has a lot to do with the first entry criterion. For 5 Schengen countries, you could say, okay, there's no reason to think there are differences. But now what we see is that the external border countries, especially in the south, but more and more also in the east, have a much bigger responsibility for dealing with asylum claims than other countries. And what you see, because of the feeling of the perception of unfairness of that system, makes that those countries are evading their responsibility. The problem of systematic pushbacks at the border is a huge rule of law issue, actually, and it's undermining the whole asylum law. And on the other hand, if people arrive, they are deprived of a reception, their claim is declared inadmissible, for instance, in the case of Greece, or in Italy, that ports are closed now for the disembarkation of people rescued at sea. And I think you cannot see that separately from this perception that it's unfair, and they call for decades already to change that first entry criteria, which is not managing. So to be brief, because I need to wrap up, I think this is a very important issue. As long as we don't deal with that, we will have this problem. On the other hand, I think it's not the right response from the northern member states to then reintroduce border controls. We have a clear criteria. We have 3 criteria in the Schengen Border Code. One of them is if in case of serious deficiencies at the external borders of control, which would cause a serious threat to the public security, and also this, lead to the dysfunctioning of the internal border area then there would be a reason to reintroduce border control. But this is not what we see. We see secondary movements. This comes from this lack of common standards in practice. We should solve it on that area and not by punishing southern member states with reintroducing border control. Sorry for the long answer.
Thank you very much, Tineke. And we'll return also to the question of external borders in a second question. But first, over to you, Vladimír.
Thank you very much. I hope you can hear me. Greetings.
We hear you well.
Thank you. Greetings, Marie, Tineke, all the participants. It's a real pleasure for me to be part of this conference. Congratulations to the EPC for very well used 25 years. On the issues at hand, I think, yes, historically, these links have been quite obvious. I think it was the Schengen Implementing Agreement from 1990 that actually formulated these links quite explicitly. And the fact that they were then separated, I wasn't around very actively in the 90s, but from those who were, I hear that there was a certain spirit of optimism, shall we say, which made them think that the basic promise of Schengen, the absence of border checks at internal borders, could be enshrined, as it was, in the treaties, while all the flanking measures had been kind of relegated to secondary law as things that were seen as largely technical issues to be solved by essentially experts. I think it would have come as a surprise to many of the protagonists that ministers and indeed prime ministers would be dealing with some of the flanking measures in such depth as they actually came to in the last decade. So now looking for a way to conceptualize the basic Schengen bargain, as we could call it, to seek the balance between functioning Schengen and functioning Dublin. I think it's a bit of a dangerous path to take, because if I could rephrase that, actually that would mean, is Schengen optional? Can member states opt out of Schengen? Which legally quite clearly they don't, but many seem to be looking for a path there. Functioning Schengen can be quite simply equated with the absence of border checks at internal borders. The people conducting border checks are police officers. They obey orders, okay? So it's quite straightforward whether the order is given or not. It is followed. The checks appear or disappear. Now, when it comes to functioning Dublin, in all honesty, I was there when I was an interior official in 2012 in the rooms where it was agreed. And despite the conventional wisdom that Dublin isn't functioning, I agree that Dublin produces outcomes that many people don't like for good reasons, but it does actually function according to the bargain reached in 2012. The letter of the regulation is kept in practice. And the bargain was difficult to reach. The negotiations that led to the current regulation took years. But there is a large scale of subjectivity about what exactly doesn't function about Dublin. The outcomes are, understood and evaluated very differently among capitals. So if we basically accepted the equation that only functioning Dublin should be a precondition to functioning Schengen, that would open the area without internal border checks to subjective assessment of all the capitals involved and perhaps some others. So I do believe that this is that's a quite dangerous and destabilizing path to take. And one very brief personal remark. I'm now connecting from Bratislava. This is my capital is, I think, the only one that's located immediately at the borders of 2 other member states. Schengen is a very immediate reality around here. It's not just a symbolic presence. It is also something that has a very deep and profound impact on the daily lives of people. So taking a destabilizing approach to this, from my perspective and from the perspective of many others, I guess, puts in danger very tangible and very practical facts of life.
Thank you very much, Vladimir. We already touched on this before, and I want to move now indeed really to the external borders. I want to hear more specifically from my 2 panelists what scope they see for continued and increased EU harmonization in this field for more EU action. I'm referring here, amongst others, to the proposal for a screening mechanism in the context of the Commission's new pact, but also to the role of EU agencies. Expanded EU action along the external borders is put forward by certain policy stakeholders and certain member states as well as a prerequisite for a functioning common European asylum system, for responsibility sharing, etc. At the same time, however, we see continued difficulties. We see certain member states putting forward sovereignty concerns when it comes to increased EU action in this area. And we also see very strong difficulties. And I come back also to the point of Tineke on pushbacks in the role of EU agencies in some of these actions and in this area, and in the general context of members in member states' implementation of EU law around external borders? For the answer here, I would first like to turn to Vladimír, turn the order around, and then to Tineke. So Vladimír, you have the floor again.
Thank you. Well, I'm quite happy that you highlighted that there's a continued EU harmonization that you're asking about, because in fact, I think there has been a lot of harmonization occurring over the past years. The total volume of EU rules that apply to the external border is quite extensive, although I think, it's only technical experts that deal with it in detail. But I think there's enough to review right now. There is enough that we can evaluate, and we can see whether it has functioned in a way that was expected and was promised, and to see whether it's adequate to the challenges at hand. I think we have enough experience, we have enough material to do that. When it comes to the sovereignty concerns, what struck me is that I haven't heard that formulation, sovereignty concerns, in some years. When in 2016 we had debate about the extended mandate of Frontex, which for the first time included the option of acting on the territory of a member state without its authorization. Sovereignty concerns had been quite obviously pronounced in the debates. But since they have proven to be a bit theoretical. So what I see is not really sovereignty concerns, even though obviously they are on the background at all times, but rather the kind of fear of unbalance between strong harmonization of processes and procedures at the external borders versus let's say, decreasing harmonization or decreasing application of rules at internal borders, which is a combination that, in my perception, is making many capitals less than content. When it comes to the processes that you indicated, screening mechanism and the role of EU agencies, again, Frontex has had its mandate reinforced 2 times in the past 7 years, I think. I guess I'm not the only one who would have expected more prominent presence of Frontex in some of the parts of the external borders. And as such, the screening mechanism, I have to confess, and I'm sure Tineke is already waiting for her turn, I don't find it to be completely realistic. I simply do not see how that would work in practice. Thank you.
Yeah, we're negotiated on it now, but it's only on paper yet, indeed. Yeah, it's a very hybrid issue, of course. I mean, we talk about common external borders, but it's still a matter of national sovereignty. And this, of course, leads to certain tensions, especially because those member states not bordering the external borders are more and more demanding towards those countries. And I have the feeling, if it comes to fundamental rights, that those southern countries, they are punished for letting in irregular migrants. Look at the reintroduction of border controls, but they are not criticized if they push back people or if they do not refer them to an asylum procedure. And this is actually, this should be more in balance. And then you could really have a common responsibility. So I see 2 problems. We have the standards, as my colleague also said, we have them on paper, but the problem is violations and non-enforcement. And this has led to member states, enjoying this impunity to also take the example of other member states. So I really feel that now rules are not complied with anymore on a very large scale, especially at the external borders. And with Frontex, also during the inquiry, we saw the difficulty that they work under the instruction of the host member states, of the border authorities, and they can simply keep Frontex team members away from the areas where they conduct those pushbacks or where violations take place. And on the one hand, I think Frontex could do much more, could be more demanding. for instance, through the operational plan saying, look, if we want to have a joint operation here, you should cooperate with us in giving us access to all the spots, to all the information. You have to cooperate, otherwise we cannot cooperate. And on the other hand, it would be good to see if that could not work. If we would need indeed to shift the competences, if Frontex would be in need of a stronger mandate, sometimes, you know, to overrule member states in case of serious concerns, for instance. That's, of course, very sensitive. So I would say let's first really use the possibilities that are out there in the Frontex regulation. And of course, also to Frontex, make serious work of these fundamental rights concerns, because up until now, we do not have the full trust that they are taken on board in the same way as the security concerns if it comes to border control. And I think for screening, what I find difficult is that the proposal of screening still gives a lot of leeway to member states. For instance, on detention standards, on reception standards. If you really want to harmonize, you need to bring it into EU acquis so that we have indeed harmonized procedures, which is not the case. And what I think is very important, and this is has to do with enforcement, we should have an EU criteria on monitoring to make sure that it's properly monitors what's happening at the border. And we need a commission to really make work of enforcement. Otherwise, nothing will change. And that would mean, for instance, infringement procedure, but also make funding of a border management conditional upon performances at the EU borders in compliance with EU law.
Thanks to both. I want to bring in one final question from my side before we move to short questions from the audience. I'll ask my panelists for short and snappy answers, so we do still have time for a Q&A with the audience. For that final question, I want to turn to the most recent state of affairs and the row between France and Italy over, yet again, the disembarkation of NGO boats having conducted search and rescue activities. There are, of course, many elements that can be highlighted in this context, but one of those is certainly the responsibility sharing aspect on which we already touched as well. Arguably, the absence of a properly functioning responsibility sharing mechanism serves as a catalyst in these kind of situations. And against that background, I want to hear from our panelists how they view the options on the table today for such a mechanism. I'm thinking about the Commission's proposal for mandatory flexible solidarity as part of the new pact. I'm also thinking about the efforts of the French presidency for making a temporary solidarity mechanism and the current efforts of the Czech presidency for widening that up a bit. What is still achievable? Also bearing in mind that the legislative term ends in 2024. And against the background of a ticking clock, should we go for some solidarity because it's better to have something than nothing at all, even if it's flexible, even if it's temporary? Or is that the wrong way forward? And should we continue investing in a systemic system that does provide that responsibility sharing across the board? Again, the order is back to Vladimír to start first. If you can keep it very short for the Q&A, thank you.
Yeah, thank you. I'm grateful that you have highlighted the shortening of the legislative of the time available for legislative work. In order to answer your question very briefly, I think that some solidarity, even if temporary, is preferable to the high ambition of having a complete overhaul of the asylum system, because I think there's just not enough time. I mean, there are obviously others better positioned to evaluate that. I think the efforts of the French and the Czech presidency have been quite positive in the sense that now there is a slim, but I think a clear chance of having some sort of achievement by the end of the legislative period. I do not remember feeling that emotion from colleagues more directly involved a year and a half ago, for instance. Okay, so I think there definitely has been progress in that. And if there is no temporary solution achievable, then I think it's hardly possible to consider it realistic to have a permanent solution.
Yes, I think my main preference would be get rid of the first entry criterion, but that will not happen at the short term. So what we have now on the table is indeed that the French reached this declaration of member states on voluntary relocation, which is simply not enough. Because you already see now, this was a conflict actually with Italy saying, look, nothing happened with that declaration. The same was for the other Med countries. So we need more, because if it's only voluntary, we see that member states do not reach out and offer pledges. We indeed are running out of time. What we agreed now with the Council is that we are ready to start the trilogues on Eurodac and screening once we have a position of the Parliament, and that will be soon. If the Council commits to have the AMMR agreement beginning of next year, and if we can start a trilogue before summer on AMMR, because if not, we will never get this adoption of AMMR legislation. And for the Parliament, it's very important to have this balance, not only security and restrictive measures adopted, but definitely a solution for the responsibility sharing of the member states. So if the Council doesn't perform this spring, I'm afraid that the pact is dead for this term.
Thank you very much. Looking at the audience to see if there are any questions. There's one in the middle. Please introduce yourself and keep the question very short. Thank you.
Could I ask somebody to pass the mic down? Thank you very much.
Thank you. Good afternoon. My name is Alex. I'm the Secretary General of ERMA, the European Industrial Research Management Association. My question would be is that we can hear about the Schengen Agreement and the freedom of movement for goods and people. If you could please relate how actually the whole system adapted itself, not for migrants, but actually with the recent pandemic that we had and regarding, the movement within the borders. Thank you.
Thank you very much. Happy to see if there's one or two more questions before I return to my panelists.
Looking quiet at the moment, Marie, so.
If there is none, then we can certainly take the question of the gentleman, and I'll add one myself, Tineke. But it's both to you and to Vladimir. You ended by stating, if the Council doesn't perform this spring, I'm afraid the new pact is dead. And my question is, what if the new pact is dead? What should come after? What should be the future after 2024?
Of course, it's quite a firm statement, but I think then if it's not feasible to get AMMR in the whole pact, I don't know if we're going to reach anything this term. Look, it's not that we don't have a system, right? We have a lot of directives, regulations on reception, on procedures, on qualification. So we are not running out of instruments. The point is we lack a problem on solidarity, on responsibility sharing. And it's not only about having an agreement on AMMR, there should be mandatory relocation in there as a minimum, I think, in order to get a solution for secondary movements, distrust between the member states, race to the bottom on the standards. So I think it's the main cause of all the problems that we are facing now. So if we don't manage, we still have all the instruments in place. And then I think we need to have a rethinking of the way we share the responsibility for asylum seekers. And maybe the other question? That's a very good question with migrants. If we have a historical look, we can remember the Tampere conclusions in 1990, where we said that long-term residents, third country nationals, should enjoy the same rights as EU nationals, including also free movement. This didn't happen. We have now the long-term residence permit, which has a very limited, way of mobility towards the other member states. But the recast proposal is pretty ambitious on that. So I think that we can applaud that. For the blue card holders, we already see some more mobility rights. And I really hope we're moving towards that direction. We have an internal market. We have integration policies of all third country nationals. So I really hope we are only improving that mobility. And one of the things on the table, of course, is also that refugees have already the right to long-term resident status after 3 years, which could also enhance their mobility rights.
Thank you, Tineke. Vladimír, the floor is yours.
Thank you. First, to address the question from the gentleman in the audience, I think there was a reference to how Schengen adapted to COVID, if I understood correctly. Now, I might be in the minority here, but actually my recollection of the way Schengen adapted to the general lockdowns that had proliferated across the world, not just Europe at the time, was a symptom of a good condition of it. I mean, if you remember those times, there was a very swift set of measures limiting movement also across external borders, across internal borders. I realized that it caused a lot of problems to the industry, to ordinary citizens. But we also managed to come back from there into a semi-normal functioning of Schengen in a coordinated way. For me, it has just highlighted that we need more predictability in these measures. These situations might come back. So we should take that lesson and really introduce more predictability into the rules that we apply. Now, Marie, on your question about what's likely or what should happen after the possible demise of the pact, I think technically there are 3 options. First, the new Commission could again aim for a large general overhaul, ambitious reform of the asylum system. The Juncker Commission has done that. The von der Leyen Commission has done that. We have basically spent 9 years now discussing quantum leap in asylum. It's for the people in the Commission to evaluate whether there is enough room for another attempt. I tend to be a bit skeptical. Then we could address deficiencies in the existing acquis. And I would like to highlight that the existing acquis and the existing asylum practices that we have are not as horrible and as deficient as sometimes they are perceived to be. We live in a moment of humanitarian triumph when you look at the millions of Ukrainians that have been given protection in Europe. We have used a part of the acquis which has been half forgotten, and I think it would deserve a facelift, maybe an adjustment of elements that could be very productive work to be undertaken. But in general, we are having a half forgotten directive that has provided protection to almost 5 million people in a matter of months. I think that's really a tremendous effort in a historical perspective. And the third possible avenue for the new Commission would be to just look for efficiencies in the current system without any major legislative ambition, which I think is a bit below what could be attempted. But I think the new Commission should do well to evaluate the experiences from the Juncker package and from the von der Leyen package to see whether or not something should be attempted again. Thank you.
Maybe one sentence. I mean, I think apart from legislation, enforcement is something that could already start now. And I think then the current standards could finally also get meaning.
Thank you very much. And thank you very much to both of you for a very frank exchange of views. I think we managed to move easily and smoothly from 1985 to what happens after 2024. Thank you also for ending with very tangible ideas for what we can do in the future. And then I wish our audience a very nice lunch break.
Thank you very much indeed. Marie, thank you for a great discussion, great panel. Thank you so much. It is indeed time for lunch now. And then when we come back at 1:30, so in 1 hour's time, we will talk about other dimensions of power. We're going to talk about the power of the green transition, come back to that issue of the power of democracy, the power of pandemics to change the world. As I mentioned earlier, economic security in an age of confrontation, the role of civil society in this era of permacrisis, and we will end the day with a closing keynote speech by Frans Timmermans, Executive Vice President of the European Commission. So I do hope you can stay with us. Just to mention, ladies and gentlemen, many of the issues that we are touching on and talking about today, the EPC has in recent days published a series of think pieces, Jubilee think pieces. They are available at the registration desk, or there is a QR code, old-fashioned printed versions, if like me, you like to read in print, or you can use the QR code to scan them. I do urge you to take a look if you haven't read them already, and I will see you back here in 1 hour. Thank you very much and bon appetit.